Working for you. A weekly talk radio program which highlights developments of national interest and the activities of your St. Kitts Nevis government. Join host Roy Williams as he presents news, views, reports, and interviews about everything regarding the activities of the Team Unity government and the building of our communities and the development of St. Kitts Nevis. Tune in and call in to interact with your government and share your views regarding the upward forward development of your community and our beautiful Twin Island Federation. Working for You is weekly, every Wednesday live from 1:30 p.m. to 3 p.m. on ZIZ Radio, Win FM, and Sugar City FM with rebroadcast on participating stations. Working for You.
Good afternoon and welcome to Working for You. I am Roy Williams. Thank you very much for tuning in to today's program. Your company is very much appreciated. Today we are going to be having a discussion on intellectual property. And we are going to hear and, we will become more educated in terms of what it is. We have in St. Kitts and Nevis an intellectual property office that deal with matters having to do with intellectual property rights and intellectual property law, although not much is known really about the office.
Yes.
But it's such an important area in terms of the intangible creations of the human intellect. Mm-hmm. Right, so I have with me on the panel officials from the Intellectual Property Office of St. Kitts and Nevis. I have Miss Jan Williams, who is the acting registrar of the Intellectual Property Office. Welcome, Jihan.
Thank you very much.
I have Miss Nicola St. Catherine. That name is always very royal. Nicola St. Catherine, who is the Assistant Registrar of the Intellectual Property Office. And I have visiting with us Mr. Rolando Hernandez Vigard, who is head of the Office Services section of the Patent Cooperation Treaty International Cooperation Division in Geneva, Switzerland. Welcome to this program, sir.
Thank you very much.
We are very happy to have you.
I'm very happy to be here with you.
You're the expert. Before we actually get into the questions and so on, I would like all three of you on the panel, starting with Jihan, to give us some background about yourself.
Oh, about myself.
It's a brief background.
Very brief. I have been the acting registrar at the IP office since 2016, October 2016. Since then, it's been, I love it. I love what I do. I love this topic and this area. I've always been about creativity. Lots of people know me involved in poetry and theater and things like that. So this is sort of like a natural progression for me, turning it into, a profession. I have, my training is in intellectual property law. I graduated with a master's from Queen Mary University in London in 2014. And I think that's about a lot of information.
Okay,
background
good, right.
information for now.
Thank you so much,
Yes.
Jihan. Mr. Hernandez Vigaro.
Well, my background is not so royal as hers, but no, I was born in Cuba. I did laws in Havana, in the Faculty of Law in Havana. Then I did a master's program in the University of Alicante in Spain on intellectual property. And since the year 2000, I have been working with the World Intellectual Property Organization in Geneva.
Okay.
So that's more or less my life.
Right, okay, so we have two lawyers on the panel because Jihan is a lawyer.
Yes.
Specializing in intellectual property law.
Yes.
And you're also a lawyer.
So you are safe.
And then Nicola
is not a lawyer.
is not a lawyer.
That's fine. I joined the Intellectual Property Office in August of 2011, and while I did not have the kind of grounding to start with, I can say I've had a few years of experience, and one of the things I have come to appreciate about intellectual property is that it allows an individual, however small their beginnings, to really achieve wealth and prosperity through the creations of their mind, so they don't have to depend on anybody to have the lifestyle that they want. And that is what I have to say about how I feel about intellectual property.
Well said,
I
Nicola.
can't wait to see how it takes off.
Okay, great. So we'll begin with Jihan, who is the acting registrar of the Intellectual Property Office of St. Kitts and Nevis. Jihan, just what is intellectual property? We hear about intellectual property, we hear about intellectual property rights, we hear about intellectual property law. Just what are those three things?
Okay, so a very easy way to describe it, I think, is if you had asked me what is property, we would know the answer to that.
Yes.
We would know our car, we would know our house, we would know our phones, we would know the things that we consider our property. Leave my property alone.
Right.
So when we talk about intellectual property, it's really no different. It's just the form is different in the sense that it's property that you have created with your mind, with your intellect. So as you said, the creations of your mind. So the same way that I could tell somebody, leave my car, leave my house, or whatever, don't enter, don't use. It's the same way that if I create something with my mind, it is my intellectual property. And it's the same way that I could tell you, don't use my poem, don't use my song, or whatever the case is, or my invention, or anything like that. So that is intellectual property. And of course, there are rights given to the owner of intellectual property that would enable them to take certain action if they notice somebody is using it in a way that they have not authorized. So the whole study of intellectual property law now concerns all the legal principles that are associated with those intellectual property rights.
Right. So we speak here about the right to ownership,
Yes.
as you were speaking about. But although I have a right to ownership of what is really my own plans and ideas and other intangible assets. So you have tangible assets and you have intangible assets. At the very same time, there are some rules for use or for
Yes.
using. For example, in academia, of course, one of the big sins or the great sin is what we call plagiarism.
Yes.
In other words, where you use someone else's work and you pass it off as though it is your own. So there is no acknowledgement of the source. You don't give any credit to where you got the information on and so on. And in fact, even though some people think it is a small thing, which it isn't, when I taught at the college, I used to have issues with that. People just going online and just
Copy and paste.
copying and pasting and so on, and no acknowledgement of source. And I had to let them know, look, this is not okay. At least you can acknowledge where you got the information from. Plagiarism in the academic world is a big thing. So we can use the work of others, but we
Yes.
have to acknowledge it.
Yes, that's correct. But in the same way, the person, even if you acknowledge someone, the person still has the right to say, don't use it.
Yes.
Because for whatever reason it's theirs, they get to determine how it is used.
So
when
they
it
have
is used.
exclusive rights.
Yes,
Yes.
and it's exclusive to them. So somebody else, even who may have bought it from them, they may not have been given the exclusive rights. They may have just given you a license to use it. So you paid for a license to use it. You didn't necessarily buy the rights to own it and determine how it could be used. So when we're one very interesting example that we usually give when we have our training sessions is photographers. You know, you might go to a photographer to take some pictures, and the photographer may give you copies of the pictures, and then you think, you know, these are my pictures. They're not your pictures. They belong to the photographer, because he is the one who took it, made it. Even though you hired him, you usually are paying for the service of a photographer, but you have not paid for ownership of the pictures.
Right.
So that's like one example where we see a lot of people think that because I pay for things, I own it. But it might not necessarily be the case.
But to protect oneself, for example, if I take some photos and I give them to someone else, I may, without really branding those photos, putting something on them to say, well, look,
Like a watermark.
like a watermark or something like that, and I give it to somebody else. It might be harder to prove that these were the photos taken by. So maybe sometimes there might be certain things to protect your intellectual property. For example, a watermark or a brand or something like that, that will not leave it open to anyone using it. So when somebody sees this, for example, at the Department of SKNS, our photos have the brand SKNS on them. So even if someone uses them, they will know, well, look, these photos were taken by us. You can trace it to the source.
But what happens when they just crop it out?
Well, that raises that
They just
raises
crop it
another
out.
issue.
I don't want this part with the SKNIS on it. They just crop it out. But so then the question, then you see your picture in, you know, this grand magazine or something, and what do you do then? It will come down to you being able to prove that that is your picture.
Yes.
So it's a balance of evidence, really, and then you'd have to go to the court and say that this person earned $100,000 from my picture, and the money should rightfully be mine.
Right. Right.
So, in terms of protecting, I mean, things like watermarks, and they're useful, not necessarily in protecting per se, but in alerting users that this is who it belongs to, and this is who you should seek permission from.
Okay.
So,
right.
yeah.
Right. Now, what some people don't like to say is that, look, if I use something that is not mine, I am stealing. I am actually stealing. If I take up something, let's say in my office I have a book. It's my book, and someone comes to my office, and you know they see the book, and as soon as I turn my back, they take the book up without really asking me for it, and they may not consider it stealing because we have a way of sort of watering down these things, you know. They may say, man, I just borrowed it. But how could you
Without
borrow it
knowledge.
without really
Authorization.
asking me to borrow it?
Yeah.
So really and truly, I can say, well, you stole my book. You took something that is not yours without getting the permission to actually take it.
Yes.
And we like to create these dichotomies in our minds about, oh, I just took it up or I stole it.
Well,
a
you,
big
well,
But
you
once
put
there's
it
no
online,
permission,
so yeah,
You would have stolen it.
yeah.
So basically, what we're talking about here is theft.
Yes.
Stealing people's intellectual property and stealing it for your own personal gain. You're gaining from somebody else's work.
Yes.
You did not do the work, the thinking behind the work, whatever you conceptualize as a piece of art, the work that you put into it, the end product of it, the research and development and all of that. You were not involved in all of that hard work, but then you just come and you just take it.
The results.
So we are talking here about what is fair and what is not fair.
Exactly. Just
Yeah.
so.
Yeah, but it's, I mean, the challenge, or rather the purpose of our office really is to raise that sort of public awareness so people understand that there are laws against that sort of theft. We have copyright legislation, we have trademark, patent,
Yes.
which is why Mr. Hernandez is here. We have geographical indications, and something else is not coming immediately
Utility
to mind.
models.
Yeah. No, but
Yes.
we
In
have
terms of
those-
rights you're talking
Yes.
about. So in other words, we have copyright and copyrights,
Trademarks.
we have trademarks, patents, and then there are also trade secrets.
Yes,
Yes.
yes. But
For
in
example, KFC. KFC has a secret, basically, to their Kentucky Fried Chicken.
The recipe that
Finger
nobody
licking
knows, yeah.
chicken. The recipe.
yeah.
You know? And of course, they keep that as their secret.
Yes, it's the money maker.
And you could see the value
Mm-hmm.
because if
Yes.
everybody could go home and make chicken like KFC, then why go KFC?
Right.
So somebody figured out using their intellect that this is the perfect recipe for fried chicken. And in order to continue to gain from it, I have to keep it secret.
Right, and so therefore, to the owner, to the intellectual property owner, that trade secret or that whatever secret it is so dear to them, and they cannot actually give that secret to anybody else because, of course, you're talking here in terms of your own company, your own profit. You're talking about
Millions.
competition,
Yes.
And
Exactly.
millions.
millions and millions of
Could
dollars.
be lost.
And another company basically
Could gain.
will be so glad to be able to steal your secret. You know, so you have to protect your secret. You can't tell everybody your secret.
Yeah. Some secrets are very valuable.
Some secrets are very, very valuable because we are talking here about competition,
Yeah.
Yes.
of course. You know, so there's copyrights, patents, trademarks, and trade secrets.
Well, there are a lot more.
And there are a
There
lot more, but those are the four major ones, aren't
Yes.
they?
Well,
those are the
tho-
ones that are protected.
Well, trade secrets are mostly protected through contracts. We don't have any trade secret legislation. But in terms of legislation, we do have copyright, patent, trademarks, geographical indications. We're also looking at plant varieties.
Oh,
You know, with all the conversation about the wonderful cannabis.
CBO.
we you know, if somebody comes up with a new strain of cannabis that is 20% more potent than other cannabis somewhere, then
We'll need
you
to be
know,
protected.
we'll have to protect that. And you know, of course, somebody would then be able to gain maximum revenue on something like that.
right.
So we could talk about books, we could talk about plants, we could talk about inventions, we could talk about practically everything.
So many things.
So
the
many
lyrics
things.
of a song, the music,
Yes.
and all of that sort of a thing.
Yes.
You know, right. And the cannabis, it's a very topical issue.
Quite topical.
And we
Quite
talk
topical.
about, as you correctly said, the different strains. I don't know what the different strains are, but I used to hear about the high grade.
Yes.
So if you have a high grade, you have a low grade. And if you have a higher grade, you have a lower grade.
No, but you can
and
have
so
different
on.
strains of high grade. Yeah.
Different strains
Yes,
of high
different
grade
strains.
and how potent it is in
Yes.
tetro,
THC,
hydrocannabinoids and so on.
Yes.
You know, THC.
Yes.
Yeah.
So that's quite a discussion. So copyrights, patents, trademarks, trade secrets, and usually that is really on the product itself. You will see copyright, or you will see
that's a notice.
a notice.
That's called the C in the circle. That's called the copyright notice.
The copyright
so
notice.
it lets you know that this book is owned by Lesroy Williams.
Mm-hmm.
So if somebody wants to use a portion of this book
They have
in their essay or whatever, this is who I need to contact, Lesroy Williams.
Right. And then the trademark as well, you see that. Some is a trademark. And
Yes, the
so you
logos
basically
and-
know who owns
Yes.
the rights.
Even if
And
you
to
don't
these
know
things.
who owns it, you know that it is owned by somebody.
Yes.
Good. Now, Mr. Hernandez, you work at the World International Property Organization. Intellectual Property Organization that governs, it's the UN body
Yes.
that governs all of this intellectual property and intellectual property rights
Within
and
the membership.
within the membership, the member states, and so on. Now, what sort of assistance, because you're here now from WIPO to offer some sort of an assistance, so the WIPO offers assistance to its member states. And you are here to offer assistance in what area?
Patents, mainly.
In patents.
But as you said, the World Intellectual Property Organization is the UN forum to discuss policies and new regulations, new treaties, new laws on intellectual property. That's one of the directions of organization. Another important direction is capacity building, training, offering assistance to member states in order to create a good environment for protecting IP rights and most importantly, as important as protecting, to make them able to enforce these intellectual property rights. Because if you have a patent but there is no way of enforcing your right, it's difficult, it's nothing. I mean, you need to have a parallel system that is not only in the office, in the IP office, but also in the courts, the police, everything that they can stop the violations of the intellectual property rights.
Enforcement.
And in that, my particular case now here is just to deal with the implementation in St. Kitts and Nevis of one international treaty that is called Patent Cooperation Treaty, PCT. St. Kitts has been a member state of the PCT since 2005, and we are trying to push a little bit for a better implementation in coordination with the Intellectual Property Office.
Okay, but let me ask you a question for dummies, Mr. Hernandez. Yeah, you have these books, so on so for sewing for dummies and
Yes.
cooking for dummies.
Yes.
Well, let me ask you a question for dummies.
Exactly. Yes.
What is a patent? As simple as that.
Yes, it's a simple, but it's a very important question actually. But a patent is a property right granted by the state that recognize your invention as protected under the patent law for a period of time that is normally 20 years from the date where you file the application, and it gives you exclusive rights on this particular invention. An invention can be a product or can be a process, and that's it. But the patent is above everything is a commercial tool because it gives you monopoly. It gives you exclusivity in the market. Nobody else can use the product or the process that has been protected without your authorization.
Okay, so there are certain things that can and cannot be patented.
Of course.
What are some of those?
But normally, discoveries, as we know them, they are not protected because they derive from natural laws, physics, etc., and they are there. You didn't create anything. For having a patent, you need to create something that should be new, should imply what we call an inventive step, meaning that you have to jump in the level of knowledge that previously exists,
Yes.
and then have to be applied. Cannot be a prototype that can no longer be used. It should be industrially replicable. Can be applied in the industry everywhere. So that's what's
Right, so we are talking innovation.
exactly.
Yes.
We are talking innovation. And then, of course, these patents, once you've developed a patent, you have to file this patent.
Well, you
An
develop
invention.
the invention
You develop the invention.
And you file
in
for
order to apply for a
patent
patent.
protection.
Right.
The patent is the title, the
Yes.
recognition, the governmental recognition of your invention.
I
So
see.
you have a land title. The patent is your title to the invention.
Okay. Now, what are two ways to file a patent, Nicola?
Patent, the
A
two-way.
patent. I'm saying patience. My goodness.
File
No,
a
To
patent.
file a
But
patent.
you know what's interesting before she answers that is
Sure.
no matter wherever you go, you're gonna hear patent or patent.
Oh.
And it's actually the same thing. I actually researched this because I keep saying, how come some people say patent and some say patent? But it actually has the same source in Latin, and then it's just that you find more British territories say patent, and everyone else says patent. So I don't
Okay.
want people to be listening thinking that we're talking about two different things.
Okay.
So
it's just a
it-
difference in pronunciation.
Yeah. Some people are more comfortable with one. In our office, I say patent, she says patent. So it's the same thing
I
though.
don't know how I say it.
So in
But-
our case,
Procedure?
Right, the procedure
The-
for filing a patent.
Okay. When you're filing an application for a patent, you have to provide basically proof that you're the owner. So it will involve specifications with regards to the invention, and that will have, you have to describe the invention, you have to explain what it is supposed to do, depending on whether it's chemical, biologic, engineering, biophysics, biochemical, you have to explain. You have to file a claim or claims surrounding this invention, and you have to file abstract, and that might involve drawings, formula, because when it comes to filing for patent protection, you have to disclose everything. It is not going to be helpful to us if we do not know what it is exactly we are protecting, because one of the things that determines whether or not we can protect a patent, as Mr. Menendez Vigo had said, is industrial applicability, industrial viability. Will this thing go anywhere? Will it become a household name? So
it
it does.
work?
Will it work? Yes.
Will
Let's
it
start
work?
with that. Will it work? Let's start with that. You also need to file a letter requesting to have requesting patent protection, and it's going to state, you have to cite who the inventor is. You have to cite what the name of the invention is, among other things. And let me pause here. If an inventor, unlike other intellectual property, if an inventor decides that they do not wish to be associated with their invention, they can actually apply to the registrar to have their name not attached, not associated with it whenever they issue the documentation, which is new to me. I didn't realize that that was possible. If you are not normally resident in the Federation, you will have to employ the services of a patent agent, which is usually a law firm, to file the documents for you. And you will have to then produce a power of attorney to give them that authority to file on your behalf. And then, of course, there are the fees. Now, let me pause here briefly to talk about the fees. The fees are around about $950, and those can be broken down with the application, examination, and publication in the Gazette. But what persons do not know is that unlike other intellectual property that is registered here, and they can have protection for a period that is around 10 years, patents are different. Patents have to be maintained every year through the payment of fees. You have to pay maintenance fees every year. And the idea behind that is, you may start off with your invention, you apply for patent protection, you do not know how far it will go, you don't know if it will work, you don't know if it will actually meet the criteria that will allow it to have patent protection. So you pay your fees every year, and if by your fourth or fifth year you realize why this thing isn't working out, it's not taking off, once you refuse to pay the fees, it will simply lapse, and that will be the end of the protection. And that's how filing goes in brief.
Okay, so there are basically two ways to file. There's a national application.
The other application, no, that was a national
That was the national,
application.
and the national application would have to follow the Patents Act.
Yes.
Okay, it will follow the Patents Act. And of course, the patent, as you suggested, is examined by the Intellectual Property Office of St. Kitts and Nevis. And if it's a national application, it's only protected nationally?
Yes.
Okay, so
You
only in
can
St. Kitts and
receive
Nevis.
protection in the jurisdiction where you file for protection.
And it's only a duration about 20 years.
But allow me to explain that. The duration of protection is actually a year, but you can maintain your patent protection on an annual basis for up to 20 years. So allow me to let you know the difference. So your patent protection may only need to last 5 years. Maybe after 5 years, it's no longer profitable for you to continue paying your annual maintenance fees. But you, after 20 years, you cannot renew it. It will go into the public domain. So in another intellectual property that is registered here is trademarks, for instance. And the short version is that trademarks are renewable every 10 years for as long as you feel like renewing it. So we have some trademarks that are on file from since before the turn of the 20th century. But in the case of patent protection, you have to renew it every year. Once you stop it lapse, and after 20 years, there is no further maintenance of that patent protection.
Okay. So you have the national application, and you are going on to speak about the second type
Yes.
of filing.
International filing. Now, I will defer to Mr. Hernandez Vigo at any point that he sees that I will need some beefing up. So I will start. There are two types. The first type would have fallen under the Paris Convention, wherein from the date of filing, you would have been given 12 months to, if the date of filing is January of this year, you have 12 months if you were to apply in another jurisdiction to claim protection from January of this year, even though you may have only been able to file for protection in October of the same year in, say, Grenada. Now, in this international filing, the onus is basically on the inventor to do everything, to supply all of the documentation, all of if the language of the country in which you wish to request and you wish to apply for patent protection is different from your language. You have to arrange for the translation of the documents, pay for your agents to file on your behalf, make sure that you supply all of the specification, claims, abstracts, everything to each and every one of these countries. And there's no guarantee, like in any other application for intellectual property protection, there's no guarantee that your application will be successful. There's no guarantee that you'll be registered. And you simply won't know until they tell you no. The other, am I on stream?
Go ahead.
Okay, lovely. All right, the other international filing that you can consider is, as Mr. Vigo, he's our expert, the Patent Cooperation Treaty. That one is special. 30 months you have to explore your options in an environment that is very, very helpful in that it will give you feedback. It will tell you, it will give I'm giving an overview.
Sure.
It will give you feedback as to whether or not they think that your invention is going to be functional. It will give you feedback whether or not it has industrial applicability. It will give you can dispute it. You have a chance to change certain things that you figure are going to be prejudicial to your application, and you can get back to them, and you have 30 months to do it. I am going to now turn you over to Mr. Hernandez Vigo because he is far better at this explaining the exact process.
Right. So the Patent Cooperation Treaty application, the applicant makes an application to Geneva, is it? In Switzerland.
One
to the office.
One of.
Could be in Geneva or could
He can
be
elect which country.
in the Intellectual Property Office of St. Kitts also,
Okay.
because the Intellectual Property Office here act as receiving office of international applications.
Okay. Now, what is the Patent Cooperation Treaty Union, Mr. Hernandez?
No, the Patent Cooperation Treaty is an international treaty that shows the importance of the patent in the current war. We have now 152 member states, and it established a system for cooperating in seeking patent protection abroad. In the patent system, we have always the tension that the patents are markets are international, but patents are territorial. I mean, it's in every jurisdiction. So how to try to find to get patent protection in every jurisdiction without spending hundreds of thousands of dollars or contacting many patent attorneys, etc., is through the Patent Cooperation Treaty. You file a single application at your national office, but in this case it's a national application. You get technical feedback during the process to know if this that you are claiming that is an invention that can be protected is really worth of the effort
Certainly.
of doing that and spending money, because it costs a lot of money to protect the patent worldwide. And then at the end of the procedure, you decide what to do. You continue or you go straight and protect in those markets that you are interested in. So it saves you money, it gives you time. That is very important when you are developing a new product or a new process. And at the same time, this time allows you to consider which markets are more interested, which countries are you have to file because your competition is there, and so on. It's cooperation for benefiting applicants of patent protection that are seeking patent protection.
Okay. Now, Jihan, what types of patent applications the IPOSKN receives?
Well, in terms of types, well, if you're talking about the national or international, we have not received a national application. No petition or division has come to our office saying I have invented something and gone through the process
Yes.
of applying. Because we get people who come in and say,
Yes.
I think I have something, but they don't follow through. But so we haven't had anybody follow through as yet. But we have people who have gone through the PCT and have selected St. Kitts and Nevis as one of the markets that they want to protect their invention in. So those are the ones that we see. Those are the ones that we receive. In terms of the nature, we see a lot of pharmaceuticals and lots of inventions relating to energy production. Particularly around 2008, 9, 10, when conversations about geothermal energy were
Right.
very high, we saw a lot of energy type applications coming in.
Okay, we have Kittitians, of course, who have developed patents. In fact, I interviewed a gentleman some time ago who was a Kittitian who actually has developed patents.
An invention or a patent.
He developed
Yeah.
invented
Patented
something.
inventions.
Yes.
Okay.
I wonder
You
who
know.
that was.
I'm trying to remember
But he
his
doesn't.
name.
They didn't come through our office.
Right.
But
He
today
works
we actually
in the
learned.
US. And,
Yeah, today we actually learned that we have Chinese Kittitians applying for patent protection.
Wow.
They're listing their nationality as Kittitian.
Because they're economic citizens.
Possibly.
Possibly.
We don't know.
Possibly.
But they're, what did you say? They're filing from China in Chinese.
As citizens.
As a
of St.
national
Kitts
of
Nevis.
St. Kitts.
But that's possible because we have a
Yes.
citizenship by investment program.
Yes.
In fact, starting tomorrow, we have a Citizenship by Investment Summit,
Yeah.
here in St. Kitts on the 20th and the 21st. It's a two-day summit which brings together all the CBI programs within the region, within the Caribbean. It's a Caribbean summit, which St. Kitts and Nevis has a Citizenship by Investment program. And so therefore it's very possible, because Chinese, we have the
But
applicants.
not only, well, we know for sure it's very possible. But whenever we start thinking about development and especially in the context of the Citizenship by Investment program, this is actually one of the areas that we never even envision it being, it coming up. But we're realizing that because of our status in terms of being a developing nation, we actually qualify for reduced fees. So our
Significantly
our
reduced
citizens,
fees.
economic or otherwise, could be the beneficiaries of reduced fees by virtue of being
Tax-free.
not
Not
tax
totally
no, no.
tax-free.
90%.
90% reduction.
Reduction.
That is very important.
Yes.
Instead of 1,300, you pay
United US
130.
dollars.
So it's significant.
So it redounds to their benefit, actually.
Yes.
Exactly.
So this is actually another area where you see economic citizens or citizens could be benefiting by virtue of being from
Yes,
St. Kitts and
yes,
Nevis.
yes. By virtue of holding a St. Kitts and Nevis
That is true.
Yes.
passport
That
and
is better.
holding.
That's much better terminology.
Yes, citizenship.
Yes.
No, but I think the patent system and the intellectual property system in general is a very good way of supporting this investment program, because all investment comes with technology, with science that is included in the package, and they want it to be protected. If not, they are not going to invest, and because if they don't feel safe enough here, it's like they are going to be copied immediately. So, so the intellectual property system have to accompany all the economic efforts that goes around the increasing the number of investors, creating new technological fields in the country, and so on, because it's important. And we are surrounded by patents everywhere. In a mobile phone, we have 1 million patents inside, but we don't realize it all the time.
Because there are so many parts and
Yes.
several parts. You have each part having a
Yes.
patent and so on.
Yes.
So everything is protected. So because it's a sector where there is a lot strong competition, there are a lot of big players that wants to have their share of the market,
High-level
and the
stealing.
only way to protect this is patenting.
High level stealing.
High level stealing.
Explain.
Yes, clarify.
I would like to think that out there are persons who wear suits and have $1 million houses who will not be bothered at all by stooping so low as to taking an idea unauthorized that will help them make more money. High level stealing.
Right. So we're going back there too. You have to protect.
Yeah, and that's essentially what our office is responsible for, making sure that we have a strong framework that inventors or creators could feel comfortable exploiting their property
In the
essentially,
jurisdiction.
so that if something happens, they could always take action.
Right.
We were talking in the office this morning, and it seems that Huawei is very popular here in St. Kitts. And we were saying that only last year, Huawei filed for more than 5,300 applications, meaning 21 applications per working day. So can you imagine the technological background that is involved, the enormous expenditure of money developing all these inventions to create 21 inventions per day and protecting them? So that's shows the importance of this patent world.
Now, Jihan, you mentioned something very interesting, that we're not getting any local, really, applications, and that the applications are coming from all over the world,
Outside.
outside of the Federation.
Yes.
And you mentioned, about the Chinese and so now, and applications coming from them, and that some of them are stating that they're Kittian, and the nationals of St. Kitts and Nevis. However, our locals are not utilizing the IP protection framework.
No, that's it's something that is such a sore point for us, because we spend every day dealing with people who have clients from Australia, Canada, Europe, all over the place. They recognize Little St. Kitts and Nevis is a market that I need to protect my product, my creativity, my product. But our own people, we're out here, we're creating freely, we're selling freely, we're doing everything just freely and not protecting it. So it's something that we've tried to we're addressing in terms of seeing how we could encourage more
Respect for
local filings. Less than 2% of our trademark applications are from locals. We just today issued 3 certificates for a young man from Old Road wanting to trademark his business name and his business his business names. He's doing 3 different businesses. So he came in and he asked, and so we were happy to finally issue those certificates to him. So he's now going to be adding into the number of local applications that we have. But we have so much talent and so much creativity here in St. Kitts and Nevis, but we're just essentially, it's like having a car and leaving all the doors open
And the key
with the key in the
ignition.
ignition.
Is that happening though through ignorance?
Part of it is ignorance. Part of it is not being able to afford the fees.
Protection.
And part of it is just relaxed. That's not going to happen to me.
Until
Nobody
it
ever
happens.
thinks that it's going to happen
Until
to
it
them.
happens.
Yeah, and then when something happens, they're running out like they say, like a chicken without the head,
Right.
trying
Right.
to figure out
fluttering around,
what can you
not
do
sure
now.
what to do.
Right.
Now, a patent in St. Kitts, as we said before, is only the invention is only protected in St. Kitts.
Yes.
What about in the region? What about a regional patent
Okay. Well,
and an applicant? How will that be protected within the region?
Well, so what would happen? We have a number of countries in the region. We have sub-regions as well. So if somebody wanted to protect, let's say in CARICOM, they would have to apply to each country in CARICOM, or they file a PCT application and select each country of CARICOM. For the past 10 years or so, there have been discussions about a Caribbean patent
Office.
where somebody would apply to that Caribbean patent office and they would get a CARICOM patent, which would then be applicable and enforceable in each of the CARICOM states.
Okay.
That has stalled a bit, but most recently, up to last week, we actually have begun discussions about an OECS patent, because bearing in mind that our economic structure is the same currency,
Right.
closer relationships, we
Freedom of
would
movement.
Yes, because we already have that existing system in place. We have begun discussions about an OECS patent, where someone would then be able to make an application to the OECS office. We have suggested that we use an existing IP office, and that IP office would then act as the OECS. So it would act within the IP office.
Yes.
And then we would, if granted, then that person would have protection within the OECS.
Okay.
So there's regional action taking place.
Okay. Fine. Now, Mr. Hernandez, while we're talking about the patent system and so on, let's put it in context. How can this help the growth and development in St. Kitts and Nevis?
Well, as far as you protect local innovation and give value to this innovation, you are getting something out of the system. And I always say that everywhere there are innovators. There are people creating new things, but they only don't know that they can be protected, they have a value, and they can be used in the market. So it's evident, and I mean, not only by empirical facts but also by scientific evidence, that the use of the patent system, the protection of inventions, give inventors the way out to first to recover the investment they do when creating a new invention, because we are talking about simple things, but if you are dealing with a incredible medication to cure something, it requires a lot of investment.
Yes.
And the only way of getting back this investment to rentabilize this is through the patent system. So the issue is just to detect the first to create a general culture on IP, on intellectual property. And it has to be done in universities, everywhere where
Schools.
knowledge can be created. And then just to attract these small inventors and to try to give value to their inventions, maybe creating governmental support mechanisms just to make it easier for them to pay fees, etc., and make the use of the system. We have a lot of successful histories everywhere that once they discover the system, they become automatic fans of it, because it's the only way of protecting, and it's a very good way of attracting investors and so on. If you show that you have a good environment, a creative environment, it's easier also to get the investments.
Okay. Now, patents are used not just locally but internationally. What is the patent environment on an international level?
Well, unfortunately or fortunately,
What
I
is
don't
it
know,
like? But what
we
is
don't
it
have
like?
international patents. Patents are only national or regional. So one patent that is protected in US, if it is not protected in St. Kitts and Nevis, is in the public domain, can be freely used in this territory because it's not protected here. So in that sense, the system works. I mean, if it follows more or less the interest of the patent applicants, they protect with where they want to protect. In the rest of the market, you can use the invention, and you are not doing anything wrong.
Unrestricted, yeah.
It's legit to do so. The problem is that the patent systems, from the point of view of applicants, are commercial tools, but from the point of view of governments, are important policy tools, because when we are talking about patents, we are talking about medications, equipment, things that can affect people's life very straight. So the government also needs to think what they want out of the patent system according to the level of development, and because we always say one size does not fit all. So the needs of St. Kitts and Nevis cannot be the same of other countries in the region, and that have to be in the included and reflected in the patent law. How strong is the protection, which particular technical fields are going to be protected, and so on. There are in the international framework certain obligations that the government have to comply with.
Yes.
But still there is a lot of freedom in how to regulate it, how to benefit everybody, because at the end it's a vector for development.
No, we need to encourage innovation and inventiveness. Caribbean people are very talented people.
Yes.
Yes, they are.
And let's face it, not just patents, but we need more writers.
Oh, yes. Yes.
We need more poets. We need more playwrights. We need more artists. And it's not because we can't do it. Because it has been proven that Caribbean people can do it.
Of course.
We've produced masterpieces.
Yes.
We've produced very great people, in science and technology. We have, a V.S. Naipaul, although he moved to England at an early age, winning the Nobel laureate for literature. We have Derek Walcott of St. Lucia,
Yes.
a very notable playwright
Poet.
and poet. He won the Nobel laureate as well. We have people like
Miss Lou.
Miss Lou of Jamaica.
You going very far. You have Rihanna. Everybody
We have
knows
Rihanna. We have Rihanna from Barbados.
I mean,
Oh, yeah.
We have
There's a lot.
Jamaica
There are so many.
Kincaid.
yes.
We have Merle Hodge. We have Samuel Selvon
Buju
from
Banton.
Trinidad, Buju Banton, and we've produced so much.
Yeah.
We're a creative people.
Yes.
We are an inventive people. How can we encourage more of this innovation and inventiveness? What do you think?
Well, I think it's a problem of culture, general culture. I mean, when governments realize that something is a good source of income, they immediately tend to support it. And you can see it in the music sector. Music in the Caribbean is a very powerful source of income through royalties because copyright is there, thanks God. And then there is something that is really well implemented all around the region. You see that there's societies to manage the author rights, the performance rights, etc. everywhere. In the rest of the IP categories, let's say like patents, trademark, you have to show that there is also a need to support this work. And when you find that you have a lot of people doing research, I'm not talking about MIT level of research, but if you are trying to find out why a coconut produce water, that's research too, and that has a value, and that can be used in several fields of technology.
Yes.
So it's just support and identify where to find people that are doing this research, this innovation, and go on and support them in protecting, in reaching out the international markets, and because finally we always defend our flag, our national tree, our national anthem, but that's also a national common heritage, our knowledge, and it's not being protected because of the lack of consciousness.
Right. Now we want to open our phone lines to see if we have some people who are going to call in with the interest.
Okay.
Yeah, okay.
So the numbers to call are 465-2555. That's the local number. And the overseas number is 1-718-577-2916. I repeat that. The local number is 465-2555. And the overseas number is 1-718-577-2916. Now, we can continue the conversation while we await any caller. One of the things we haven't identified, and you agreed with me, Gian, is that probably people are not taking advantage of the IPO SKN office because of ignorance. And one of the things I noticed that you're going to do while Mr. Hernandez, which is the H is not pronounced, and I speak Spanish, so I should know that, you know. Is that you're going to host a public sensitization seminar. Could you tell us a little bit about that?
Yes. So tomorrow morning, that's 20th June, we will be at the Solid Waste Management Conference Room. That's up at Taylor's Range. We will be discussing patents generally. We have extended the invitation to the Clarence Fitzroy Bryant College. We've extended it to attorneys, patent attorneys, government officials who may deal with, you know, creating and dealing with international trade and things like that. But people who are generally may benefit from information like this.
Yes.
Because one of the things that we believe, and you've highlighted it as well, is that people are doing things. It's not that we're not creating, it's not that we're not inventing, but we just do it. And we're not taking it very seriously, maybe not even noticing that you could take it more seriously and protecting it and understanding what would happen if, you know, you've created something and you're using it in public and somebody comes and says, "Oh, what's that?" And you go and you explain everything to them because you're so proud that somebody is interested in something you created, and they walk away and they say, "Oh, that was nice, have a good day." And then they could walk away and take your ideas and your plans and your everything and file an application with our office. Next thing, we could give that person a grant, and then you know what could happen? That person could come back to you and say, "Stop using my invention."
Yeah.
Because they have the right. So it's for us to realize that we may be doing things that are valuable. And if we want to take it to the next level of commercial exploitation, you have to protect it.
You know, Jihan, what comes to mind is that novel by V.S. Naipaul. I don't know if you've ever read it, but Miguel Street. And in Miguel Street, Miguel, of course, was always building something, was always doing something. But whenever you ask Miguel, what is it that you're building, what it is, he never had a name for it. Never had a name for it. You know, so it reminds me of what sometimes we're doing things, we're creating things, but give it a name and protect it.
Yes.
Yeah.
And a lot of times, I mean, we're talking about it, Rolanda gave us some really interesting statistics this morning about, you know, who's filing the most patents. And right now it's concentrating around digital technology and communications and things like that. But, you know, there's a simple product that I didn't even realize that has a patent on it. But okay, I have dreadlocks or locks, and there's a particular tool that the person who does my hair uses. So it allows you to pretty much like knot the hair. There's a way of doing it, and they're called interlocks rather than the regular twisting that we would do. And there's a patent on the tool.
Yes.
So something as simple as that, like figuring out how to comb your hair and some kind of tool that makes combing your hair different, some kind of variation on a comb that I don't know, causes some sort of functional extra value on it. We saw a patent on I saw one last week about a toothbrush that had toothpaste in the handle of the toothbrush, so, and you just push up and the toothpaste comes up onto the brush. So simple things like this, just adding these little variations on things that make it a whole new product. So it's you know, when we talk about patents, we don't always want to be talking about in energy and technology. These are very basic things that could be protected. I saw, if anybody knows the show Shark Tank, you may be familiar with that show, where people just create things and they go and pitch to business owners for venture capital. So I create something and I go to these 3 people and I say, please invest in my company. And these are things that they create. And there was one product that up to this day I still can't figure out, why didn't I think of this? Where you might be eating soup. We just had soup. We might be eating soup. And you put the bowl in the microwave. And you want your soup very, very hot. But you know now when you go now to open the microwave and take out the soup, the container is very hot, you can't touch it. This person invented a mat that you put in the microwave under the bowl, and when it's done, you simply take up the mat so you could hold the bowl, and that's a patent. That was a patented protection. It's like a special mat that allows you to hold a hot container out of the microwave. And it's very basic things like this, and you're thinking, this is so simple, like why didn't I think of this? But somebody did, and somebody went the extra mile to figure out a new way to do it. They added an extra inventive step, and it's something that you could replicate again. That's the 3 things you need for it to be a patent.
And it's with it becoming a household name.
Yeah.
Right, and you know, we are talking about niche markets.
Yeah.
For example, the Ministry of Tourism, and you're saying, let's get these niche markets, and you know, there are things that we can do, little things and so on, that we can come up with and so on, that you know, tourists are looking for. And then we're talking about, I noticed, you know, we have the Ministry of International Trade, we have the Bureau of Standards, and you know, all of these government agencies who really should take an added interest in what we're discussing today.
If I would willingly accept the challenge that you name me a government ministry and I could tell you how IP relates to it.
Right.
Any single ministry, I could take that challenge.
Right.
There was something I saw recently. There's a restaurant in, I think somewhere in the States, in Arizona or somewhere, and they have gone through different islands doing drinks. And so in Cuba it might be a mojito, or somewhere else you might see something else. And you know what was there for St. Kitts Nevis? The killer bee.
Wow.
Sunshine's killer
Yes,
bee.
yes.
And they're selling that in Arizona.
Wow.
Sunshine's killer bee. Everybody
So
knows
the recipes,
Sunshine's killer bee is associated with Sunshine's Bar in
Penny's
Nevis.
Beach, yeah.
Is it protected?
Perhaps not.
Probably not.
No, it's not.
It's not.
No, it's not. Have a
Working for you, good afternoon.
Good afternoon. Lovely program.
Yes. Thank
Okay, my
you.
name is Vance. I'm also into the invention business. I would have earned myself about 4 United States patents thus far. I would like to say a little about one, that is called red light run protection, or red light run safety pro. Now, what is red light run safety pro? It is a feature I have added to the street light, that if anyone who is waiting for the green light, while they're waiting, it so happened that the time comes for the green light to turn, for the red light to turn to the green, it so happened somebody run the red light, it so happened if the light had gone green, that person would have been an injured or dead person. But what I have come up with is this idea. You have this flashing red light which I've introduced. So when someone runs the red, what would happen? The light would change from red light to a flashing red light. It runs for about a second to a second and a half. That is sufficient time for this guy to blaze through. When he passes, then the thing will realize that there is no further threat, and then it will then turn it to the green light. The person then proceed safely. I have a United States patent for that. If you want to get a clearer picture of what I'm talking about, you can go to YouTube. It is Red Light Run Safety Pro. I repeat, Red Light Run Safety Pro.
That's Red Light Run
patented.
Safety Pro.
Safety Pro.
Red Light Run Safety Pro.
Okay, thank you.
Thank you.
But you see, we know that. So it's good to know that we have creators, but and inventors, but and they're taking the opportunities from the US and other places. But it's good to know too that we have the protection here.
Right. And Jihan, CFBC students now are into robotics. I mean, they reach very far with robotics and so on.
Yeah, they were in the top 10 in the world.
For a small
2 years
country
ago,
like St. Kitts and Nevis, reaching so far. Students at the Clarence Fitzroy Bryant College, which is a tertiary institution, post-secondary, just before university. Sometimes it's considered first-year university. And I used to teach there, but robotics.
Yes, this is one of the sectors that are now creating a lot of new patents, artificial intelligence, all of this, because it's something that there is also a lot of competition. You see that IBM, Microsoft, all of these people are going on these issues. Also, Bank of America, Visa, MasterCard, because they are facilitating everything through artificial intelligence. So it's a sector that there are tiny developments, because it's not big things, it's tiny developments, but still they protect everything. And you see that just IBM, they have more than 100 patents on artificial intelligence. That is an example.
Gian, I know that you're a poet, and I know we've met at same gatherings, saying poems and so on. I don't have my poems protected. Do you?
I've actually I just to see how the process is, I've deposited some with the Library of Congress in the US. But protecting your poetry is nothing that you it's not no registration or anything like that. You just have to make sure you could prove that you are the creator.
Okay. Now, in terms of your office and public sensitization, apart from the seminar that you are going to have, do you have little leaflets and all of that sort of a thing, or somewhere where somebody can go to learn more about patents and intellectual property and all of that, Nicola?
Our website. Website is IPO.gov.kn.
This should be
we have
rolling off your tongue.
an SKN involved there, so
IPO.gov.kn.
IPO.gov.kn.
And this gives you intellectual property information that is relevant to St. Kitts and Nevis. If you go on Google and you Google copyright, you are likely to get copyright information from the US or some other country. But our website tells you what applies here in St. Kitts and Nevis.
Okay, good.
And I should also say, in terms of public sensitization, we have also received requests from groups or departments, government departments, wanting to understand it more. We got an informal request from the Ministry of Finance, wanting to understand what's happening. And we've done it with the Ministry of International Trade. We've had interest from Ministry of Education. So people come to us as well if you just want to know more, and we will tailor something specifically for what you want to know. We've done it for musicians. We've done it for photographers. We've done it for
culture.
We've done it for a lot of people.
Right.
So if you just want to understand how it applies, you could just let us know that you're interested. Also, we of course also put on our own events. I miss entrepreneurs. We did about 3 sessions with entrepreneurs last year. But it's for if people want to understand more. You just come and let us know, and we.
I'm happy that you mentioned musicians, Jihan, because we have quite a number of musicians here in the Federation. Do they register with the office?
No, musicians don't register
don't.
with
ECHO?
our office.
There's ECHO?
Yes.
ECHO.
ECHO is the Eastern Caribbean Collective Management Organization for Music Rights. So they are the organization that collects license fees. They issue licenses for music playing in the public. So musicians can register with ECHO. That's who they need to register with, not our office.
How many do though? Do you have any idea?
I think the last I heard it was about maybe less than 40. It's not a lot. But people need to understand that royalties is one way, perhaps the main way, that you will continue to make money off of music. Because other than that, here in St. Kitts and Nevis, our musicians are making money from public performances. And when you call De Jour, for example, to perform, you're paying De Jour, but you're not paying the person who wrote De Jour's song. And the people who get royalties are the songwriters and the music producers. So it's not, if Rolanda and I wrote a song and Nicola went to perform, we are the ones who get the royalties. She just performs. She's just a performer.
I get my performance fees.
Yes. So that's how songwriters and people who make beats and people who make music, that's how they make money.
Right.
But they have to register with ECHO, and then ECHO then goes out and monitors public venues and people who play music and so on in public. They monitor and they collect fees from them, and then the fees that they collect, they pay royalties out of.
I know even our calypsos, some time ago there was some issue about people using other people's rhythms and whatever thing and all this kind of a thing. Those are issues really that would fall on
That's straight copyright infringement.
Yes.
Yeah.
Okay, something we did not talk about, we did not discuss. Mr. Hernandez Vigard. In terms of law, that aspect of law though, infringement, protection against infringement, and if somebody really infringes upon my right, what recourse do I have? I don't think we touched on that, Nicola.
I might not be the best person to speak on
The lawyers?
the exact, but I can safely tell you that I'm reasonably well read, and every last legislation on intellectual property has an entire section on infringement, what fines, what recourses, what court action could be taken. It's there in black and white, nicely fleshed out.
But it's all about courts.
Yeah.
It's all about
It's all about the law.
Because intellectual property rights is a private right.
Right. So, and then of course, when people do that, they go to people like Jihan.
Yes.
No.
Well,
Because
not
I'm
no,
working
but she's
for government.
she's working for government. You're not, she's
Yes.
not in
I'm
private
working
practice.
for you, yes.
She's not in private.
So you go to the government lawyer.
She's not in
not
private.
the government, the private lawyer.
But let's face it, Jihan,
There
you
was
are an
no-
IP attorney. You are
Who's
IP
working
law.
for
You're
you
who's
in
working
the
for the government.
government,
Who's
yes.
working for the government.
They would
Right.
still go to Jihan, and on occasion, if it's not too technically legal, they would come to me for us to advise them that yes, your suspicions are confirmed, your rights have been infringed, you need to seek some.
Well, we
legal
wouldn't go
recourse.
that far. We would say, if just speaking generally, because we can't give personalized advice. So we could only give general advice and perhaps suggest that you should seek legal advice on your particular situation. But we've had situations where people have come to the office on the same issue about music being used, and I didn't authorize this particular company to put my song in an ad. What should I do? Go see your lawyer and just guide them to the copyright
Okay,
Act.
right,
So
right,
we
right.
can't give
I
them-
know what you mean,
yes.
but at least you can act as, people who recommend. and provide advice, and you can
Not personalized
not
advice.
personalized advice, but advice from the
We raise
standpoint-
awareness.
You raise awareness, right? Now, I bring my patent and so on. Am I given a license?
What do you
What
want?
about a license?
Make sure you're using the right
Okay,
terminology.
Yeah.
when you
bring
say
your
a
what?
license, if you're the owner of the patent, you're the one who grants the license for somebody else.
Oh,
to
I
use
see.
it.
Okay.
So what did you have in mind?
for it?
Okay. Okay. So,
What-
so tell me, how does
But
this
what
license
what
thing
did you
go?
have in? Okay,
The licensing. So you've created an invention. You've gone through the process and you have a patent. Somebody determines that I want to use it, then you give them a license.
Okay, so you give them
and
them
you
the
will
right.
determine
This is like a permission to
It's
use
a permission
right.
to use.
against the
For,
payment
uh,
of a
yeah.
royalty.
so
Right,
so
okay.
I will pay you maybe $250,000 if I am allowed to use your invention for X amount of time for these purposes. You and I will sit down and determine what you're giving me permission to do and a price that we think is fair.
Yes, it's a private contract at the end.
Yeah.
yeah.
Even the payment is have to be also decided. You can pay a lump sum. You can pay according to the how many products you sell, and so on. It can be discussed, and it depends on the product, the technology, the market, the size of the market, etc.
But it's important to note that our office is not involved after we give you the grant of the
Yes.
patent. Bye.
Okay.
We're not involved. So you can't come to us and say, I see somebody using my invention. That's
Fix the
not
problem.
ours.
We're
That's
going
not
out to
our
the nest.
jurisdiction. Yes.
Right. Okay. Well, we are out of time.
I know. Yes.
Is there anything that you want to say?
No, I think
Senor
I want
Hernandez.
first to congratulate the office. They are doing a lot of things just to keep up with the non-existent demand, but just to creating the demand.
Just in case.
Because it's an issue that is very important for development, and I think they deserve a little bit more of support, and because everybody thinks that IP relates to the IP office. No, it's a question that relates to the whole system, not only in creating but also in stopping infringement and things like that. I mean, custom, police, everybody has to be involved. But the source of most of the knowledge is in the office, and they are doing very well.
Okay, Jihan?
Sorry. Well, just to, again mention our sensitization seminar if you want to know more about patents, how you could get protection, what can qualify for patent protection, how does it work in terms of the PCT applications. We'll be at the solid waste management conference room tomorrow from 9 to 12, and so it's open to the public, and I think it will be a good session for people who might be serious about it. Like Mr. Hernandez says, it's not something that we do or we have to, we're not asked to do it often, but the fact is that we have to do it just in case there's even one person who's even interested in taking their invention forward. So we're making sure that we build the framework, and that the framework is very strong to support the level of innovation and inventiveness that we need to see coming out of St. Kitts and Nevis. We can't always rely on other people's innovation and inventiveness to support us. We need to start creating our own, so relevant to us, so that we can sustain ourselves even more. So we're here for that sort of support. Again, we are located in the cable building on the bottom floor. Our website, www.ipo.gov.kn, and we're pretty open, relaxed office, and we're trying our best with only a staff of 5, but we're trying our best, and I think we're making some headway, trying to work for the people of St. Kitts and Nevis.
And it all starts with all of these things, inventions and whatever, start with an idea. You conceptualize an idea and you follow through with that idea. And the question I would ask though, how do I protect my idea?
Well, you can't protect an idea.
You cannot protect an idea per se.
Lots of people have ideas.
that is one of the
what gets
things.
protection is the one who takes it further and actually
solve a
An
problem.
expression.
actually expresses
Expression
it.
of the idea.
Right.
So you don't
So therefore, do I-
you don't get the
So
the
it means that
protection
I
while
don't
it's
have
in
to,
your head.
I can't share my ideas with everybody.
You shouldn't.
Exactly.
That's what I mean.
Yes.
That's the protection I'm talking about.
Yes.
I must protect my own idea.
Yes. So the protection
starts with
for
you.
the protection of ideas is silence. Yes.
Yes. So I have to protect my idea.
Yes.
Yeah, of course.
And then when you have expressed it, in an invention or some sort of literary work or artistic work or some trademark, then you come to us.
Right. Nicola?
Well, I don't need to add too much except that I reiterate the invitation to the patent sensitization seminar tomorrow. I am hoping that people will walk away with it with a better understanding of patents and greater respect for intellectual property, because patents actually draw the largest amount of revenue generation than most of the intellectual property that we protect here. So, thank you for having us.
Okay, well, I want to thank all three of you for coming. When you first sent me that you wanted to come and have this discussion, it was postponed for a while because then
I got sick.
you got sick,
Yes.
and then I think you were here before, were you, Mr.?
He was on his way.
You were on your way. And then everything had to get sort
in the
of
ear somewhere.
postponed and so on. Nicola came and she told me and so on, and but we're here today.
Yes.
And we thank God for that.
Yes.
And I'm sure that you will come again, Mr.
I hope.
Hernandez,
I hope to be here again.
and continue to, through your good offices of the WIPO, to help the local office
We are
here
open.
in St.
Always
Kitts and
helpful.
Nevis.
We are
Always.
always open to contribute in any way
Right.
to the
and
local
it's something. If I could add just finally, Mr. Williams, I would even challenge you to think about how SKNIS could benefit from IP knowledge.
There we go.
Because you all do news items, you're
We
around
do.
taking pictures,
Beautiful footage.
you're doing lots of things, but is SKNIS protecting its own
Hi.
work?
Good question. You leave with a lot of food for thought, and
Yes.
it's a good way to end this program.
Yes.
Thank you.
Right. So I want to thank all three of you, and thanks to our listeners and our one caller for today. We continue to appreciate you tuning in to Working for You from week to week. Next week, we will be back for another edition of Working for You. We should have Skellig on our program next week. Until then, I am Lesroy Williams. Take care.
Working for you. A weekly talk radio program which highlights developments of national interest and the activities of your St. Kitts Nevis government. Join host Lesroy Williams as he presents news, views, reports, and interviews about everything regarding the activities of the Team Unity government and the building of our communities and the development of St. Kitts Nevis. Tune in and call in to interact with your government and share your views regarding the upward forward development of your community and our beautiful Twin Island Federation. station. Working for You is weekly, every Wednesday live from 1:30 p.m. to 3 p.m. on ZIZ Radio, Win FM, and Sugar City FM with rebroadcast on participating stations. Working for You.